Good morning, everyone. All right, welcome. First and foremost, I just want to thank you for taking time out of your schedules and coming to this conference. Whether Helena is your home or whether you've traveled miles to get here, this is an important topic, and we so appreciate you taking time out of your schedules to focus your attention for the day on the way things are and the way things can be, and I think we'll see plenty of both of those. My name is David Bell, and I have the privilege of opening the conference today and of introducing the various speakers throughout the agenda this afternoon. I also have the privilege of leading the men and women at ALPS, and ALPS is now the largest direct insurer of lawyers' malpractice in the country. But we also are quite blessed to call Missoula, Montana our home, our headquarters, and our home base. In addition to ALPS, in my spare time, I was asked last year to chair the Montana Justice Coalition. I think asked or conscribed, I think they might be one and the same. But it's such a privilege to begin to chart that course as we lead up to the days of our next legislative session. The Justice Coalition is, for those of you not familiar, the legal reform subsidiary of the Montana Chamber. And the goal of the Justice Coalition is quite simple and quite clear. The Justice Coalition works towards a stable and predictable legal climate in our great state. And to the extent that I can add some modest contribution during my time piloting the coalition, it will be to accomplish really this objective. As we lead up to the next legislative session, the identification of opportunities for judicial reform through the legislative process, listing those opportunities, prioritizing those opportunities, assigning realistic probability, and allocating the political, relational, and financial capital to execute on that strategy. Frankly, it's a quite simple blocking and tackling exercise as I see it, mainly focused on project management, but I hold myself accountable in accepting that role and ensuring that we execute on some of the many pioneering work that's already been done in other states for which this great state would benefit just as much. So that is the topic that we're going to focus on today, and this conference would not be possible without the sponsors and support of today's conference. I'm going to tell you about 9 companies. If you're close to the middle of the rows, you'll see them too. And I just asked for some recognition, but please do wait until the end. First and foremost, the United States Chamber of Commerce, and specifically the Institute for Legal Reform, the ILR. They're the premier sponsor. They've also been a partner for many years. This is a fantastic strategic partnership, and so we so appreciate the ILR's partnership again this year. The American Tort Reform Association, Browning, Kalizak, Berry, and Hoven, BNSF Railway, Crowley Fleck, the Montana State Fund, Northwestern Energy Group, Town Pump Hotel Group, and the Van Horsen Law and Government Group. Please join me in thanking our sponsors for helping make this possible. Also, in conjunction with this conference, the timing is great. For the release of the 2018 judicial review of the Montana Supreme Court and of the Workers' Compensation Report. You should have a copy of the 2018 judicial review. Bridger, if you could hold up of which one of those that looks like, that would be great. This is, as Harold, our first speaker, might point out, this is rather unique. The work that is done within the state of Montana to summarize and communicate the work of our Supreme Court and the Workers' Compensation Court is very helpful, and this explains the business impact of relevant cases for the 2016 and 2017 years, and the approach is quite clear. It evaluates the justices based simply on how well they upheld the rule of law. And so please take this, and please also request additional copies to distribute it, because if you or someone you know, inside or outside your organization, is the type of person like me who is very interested in judicial decisions and how they shape the legal framework of our state, but frankly not willing to read every decision in its entirety as it comes out, then this judicial review is for you. It has the facts and it has the holdings. It's quite clear. It's a great summary. The 2018 Judicial Review is for you. Finally, and before I introduce our first speaker, it's also important for you to know that the Montana Chamber has a 10-year strategic plan. Launched last year, it is called Envision 2026. And among the objectives of the 10-year strategic plan for the Chamber, one of them is the metric of where Montana falls on the U.S. Chamber's Institute for Legal Reform's ranking of state legal climates. There was a time, not too many years ago, where Montana's ranking began with a 4. And if you were 40th something, that wouldn't be so bad if we had 250 states in the union, but we don't. And in the years that have followed, Montana has climbed up the ranking. And the big question now is, where does Montana sit in 2017-18 within that ranking? And with that, it's a perfect segue to introduce our first speaker for today, Mr. Harold Kim. Harold serves as the Executive Vice President for the U.S. Chamber's Institute for Legal Reform, the ILR. He's a former Special Assistant to President George W. Bush and served as the liaison for the President to the Senate on matters involving the security, the judiciary, civil justice reform, and many others. He was also counsel to the Senate Judiciary Committee from 2003 to 2007 and played a key role in the passage of the 2005 Class Action Fairness Act. Prior to his government service, Mr. Kim served as a senior litigation associate at the DC-based firm Patton Boggs. It is really a pleasure. He has left the swamp to join the snow, and it's my pleasure to introduce to you Mr. Harold Kim. I'm also IT specialist.
Good morning. And it's been a great morning. I was telling Webb and Bridger last night, when they extended the invite to me sometime last year, I jumped at the opportunity because it is so great to get the hell out of Washington. I, for once, first time this year, had a great night of sleep. I slept like a baby. I had a great breakfast. I feel good. The air is clean. The politics are great here. I'm out of the swamp. I'm out of the Beltway. So thank you very much for having me. I'm going to talk about three things today. Number one is what is going on the legal reform landscape. What are some broader trends that we are seeing? Somehow connected with what's happening in Washington, but what we're also seeing in the states. Secondly, I want to talk about some emerging litigation drivers, some of the things that the trial lawyers are using and pushing in order to push the envelope on liability against the companies and the business interests all throughout the country. And then third, I want to talk about Montana and the improvements, a testament to many of the folks in this room in the legal climate here in the state. So, for starters, and as a tribute to the great Stephen Hawking, who passed away earlier today, I want to harken back to a time where we had a fundamental principle of physics established 350 years ago by Sir Isaac Newton. And it's the third law of motion. I'm not a physicist, I'm just a lawyer, but I did stay at a Holiday Inn Express a few days ago. So his third principle of motion was that for every action, there is an equal and opposite reaction. And I think that this principle is a good metaphor to what we are seeing here in the country when it comes to our legal system. I hope this works. There we go. It works. Motion. The Trump presidency carried with it a deregulatory agenda that we saw happening throughout 2017 and which we are witnessing in 2018. Now, the president's tweets are certainly consuming the headlines. The media is focused on Russia. The media is focused on what's happening in the White House with the staff shakeups. But there are a tremendous number of agency actions that have occurred over the past 15 months that have had an incredible impact on what's happening with the regulatory state that was built through the last 2-3 decades. Here are some proof points that you'll see. Very early on, President Trump issued one of his first executive orders directing the agencies to basically repeal two regulations for everyone that comes online. And he instructed the agencies to do this all across the board: Department of Transportation, Health and Human Services, CFPB. And so this has really it set the tone, frankly, to look at the way that the bureaucracy was working and how it impacted everyday business matters. The Consumer Financial Protection Bureau was also one of the primary targets of the Trump administration in terms of the reach that they had with financial services organizations all throughout the country. There was a big fight there about its legitimacy. This was really a creature of Elizabeth Warren that was authorized under the Dodd-Frank law during the Obama administration. The Federal Communications Commission repealed net neutrality rules that gives internet access providers more depth and ability to provide internet services based on a tiering of actual processing speeds for the internet access and for not having basically a socialized effort on the internet. And then the Department of Justice is one agency that really has spearheaded the envelope on the deregulatory front. First and foremost, the False Claims Act has been a real weapon used by federal prosecutors as well as plaintiff lawyers to go after companies who have dealings with the federal government. And it's been used by whistleblowers to get huge awards against the healthcare industry, financial services, manufacturing. The Department of Justice issued a directive to its attorneys by saying that you cannot use agency guidance that is non-binding as a predicate for False Claims Act liability, because this guidance was not issued through the normal notice and comment rulemaking process. It's not a rule. So you cannot have a bureaucrat who issues a memorandum bestowing particular obligations on a company, and if a company somehow violates this memorandum, that should not be the basis for civil and criminal liability. And this is something that the department issued with very little fanfare, but it's going to have a profound impact in the way that False Claims Act litigation is going to be brought. This is just a snapshot of what we've seen to date. And it's a sustained effort by the administration to really open up a deregulatory policy agenda, which is having an impact on corporate America. But of course, with every action, there is a reaction. And so the reaction that we're seeing is that all our friends in the environmental movement, the unions, consumer awareness groups, trial lawyers, they're getting the hell out of Washington and they're moving to the states. And they're moving to the states at a very, very broad level to establish national policy. And what we're seeing is the rise of local actors. Certainly states and the state attorneys general have been very involved in issues like the opioid epidemic. Litigation has been the driver to try and hold companies accountable through the entire supply chain for perceived losses and the health impacts in the various states. There is a multi-state investigation brought by the state AGs, but you've also got cities and counties and Native American tribes piling on, suing the manufacturers, suing the distributors, the pharmacies. And this is really a sign of things to come. And of course, we can't forget about our friends in the plaintiffs' bar, because they are the ones who are bringing the litigation on behalf of these entities with a huge contingency fee award at the end of that rainbow. So this is basically tobacco 2.0 in the opioid context. We're also seeing it with climate change. Several counties in California have sued the big majors under public nuisance theories for the rise in sea levels, for the environmental catastrophes that they are perceiving throughout the state of California. But we're also seeing it in New York. And again, the plaintiff lawyers are at the steering wheel here, driving the litigation under contingency fee arrangements. So this is a new method of litigation that's being brought. We're seeing it everywhere. And as Washington becomes much more business friendly, again, to restate the point here, our opponents are going to the states, and that's why the states are so much more important to focus on as part of this legal reform movement. And it's not just litigation. Wage and hour related ordinances and laws are being pursued in places like New Jersey. And it's only going to be much more accelerated as the deregulatory machine in Washington continues to push forward. So that's tranche one. Are there any questions about that? Is it way too depressing? Hopefully not. Okay. Let me now talk about emerging litigation drivers. What I'm going to really focus on is the trinity, or the unholy alliance, of three major litigation drivers that the plaintiff lawyers are using. Number one is getting the funding for the litigation. Where's the money coming from? Number two, how do you get the people to sue? In mass torts, and that is connected to the advertising that we're seeing. How do you overwhelm a defendant with 50,000 claims of people that you've advertised out there on the internet, television, otherwise, in product liability, other types of cases? And then number three, how do you backdoor changes to the law so that it becomes a lot more elastic, so that it gives cover to activist judges at the trial court level who can go beyond traditional principles of tort law, negligence, product liability, these things. And I want to focus on something called the American Law Institute, which is a little mind-numbing, but bear with me, there is a point to this. So emerging litigation driver number one, third-party litigation funding. What I mean by this is that you have hedge funds in New York, in Chicago, in Australia, and in the UK that are actively investing hundreds of millions of dollars in lawsuits. And these investors are expecting a return at the end of the day. Once upon a time, litigation was brought under contingency fee arrangements where plaintiff lawyers would float the case, especially in class action matters, asbestos. But now there is a very different financing model. And a lot of these claims are being bundled together as a portfolio investment. Burford Capital is one of the largest third-party litigation funders in the world. And just in 2017, they had committed $1.3 billion in litigation. And in the first quarter of 2017, they reported net earnings of $140 million. That's their profits, folks, and that's net. That's after taxes, expenses, and costs. So obviously, I'm in the wrong line of business here, given the amount of cash that they are taking in. But there is an enormous amount of money on the streets, on Wall Street, through the markets, to capitalize these types of investments. So imagine the legal problems that are associated with this. Normally, if I'm going to sue David or David sues me, I'm on one side of the V, he's on the other side of the V. But lo and behold, you've got this third-party litigation funder who's kind of lurking in the background that has a very strong interest in that case. They could care less about the actual dispute that we have as long as they have a return. And they can control the case. They can control settlement negotiations. And the biggest problem is that judges have no idea that these folks are in the background. So what we've been doing is encouraging the federal judiciary to amend their rules on discovery to require disclosure of these types of arrangements. The judges ought to know, the parties ought to know who are the real parties in interest. And it's certainly important in the class action context because one of the certification standards is adequacy of representation. So if you have a hedge fund that ostensibly is being represented by a plaintiff lawyer who has to have a return on investment, then who has the duty, the fiduciary duty and the obligation? Does it go to the hedge fund or does it go to the class plaintiffs? I would continue to say that it would be the class plaintiffs and that the fiduciary obligation should not be to a third-party litigation funder. Yes, sir.
I've got a question. When you talk about trying to amend the federal rules, this is somewhat granular, but are you talking about amending real party in interest or initial disclosures, combo of both? What's the roadmap look like?
Excellent question. So we've submitted a petition to the Federal Judicial Conference, and they have a process under the Rules Enabling Act to amend the federal rules of civil procedure. So this would be a direct amendment to Rule 26, and it would require disclosures, initial disclosures prior to formal discovery happening. And one of our arguments is that if you're in federal court, one of the first things that you have to turn over are insurance agreements. Because if an insurance company is going to indemnify or cover defense costs, that is something that's disclosed up front. And we think that that same principle should apply equally to third-party litigation funders because they're funding the litigation. And frankly, there is more of a growing awareness among the federal judges about this practice. The Northern District of California just last year made some local rules changes requiring disclosure of these funding arrangements. We're trying to get this more on a uniform national scale through a rules change. And I will tell you that the funders are fighting this tooth and nail because they understand what's at stake if some of this stuff gets out. Lee.
Is the proposed amendments limited to just disclosure of the existence of a third-party litigation funder, or is there a representation that would also
So the agreement, usually what we are looking for is the agreement itself, because that's going to spell out the level of control. And that's one of the big issues. And now the other side is going to come back and claim work product privilege, attorney-client privilege. Some of the courts throughout the country have actually addressed some of these issues, and it's an emerging area of law. But we think that the judiciary, the federal judiciary up front, should have a concrete rule to have this out there and to address some of these privilege issues through the rule.
Seems a lot like the insurance policies.
Yeah, that's what I would argue. Okay, so hedge funds, money. That's what drives a lot of the litigation, but you can't litigate unless you find the people to sue. And it's because of that we are focused on trial lawyer advertising. How many folks here in the last week have seen a trial lawyer ad on television? It's amazing. It is absolutely amazing. On television alone, the trial lawyers in 2017 nationally spent over $1 billion on TV. That's more than Apple, Ford, Honeywell, major corporations. $1 billion, that's a lot of change. And they know that there is a very active market. They're saturating national media ad buys. I watch MSNBC and Fox News. I cannot get away from these trial lawyer ads on asbestos, Pradaxa, Xarelto. I mean, it's incredible the amount of saturation. And actually, the public awareness about asbestos and mesothelioma. There are more people who connect asbestos and mesothelioma in this country than who know who the Vice President of the United States is. I would at least submit to folks here. But this advertising is something that we took a little more of a critical look at. I don't know how many folks picked up this research here, but this research took a different look at advertising, and that was the public health impact of some of the ads that you see. When you see a particular prescribed medication, like Pradaxa or Xarelto, being associated as a bad drug, imagine what kind of impact that has if your doctor prescribed you Xarelto or Pradaxa. So we did a little bit of public polling of people who actually took these medications, and this study and this research from last year shows that 1 in 4 Americans would not take their prescribed medications after watching some of these ads. The FDA has had over 60 adverse events associated with people not taking their medications. People have died, they've suffered strokes, pulmonary embolisms. So this is a public health issue because of the way that these ads are being run, because of the way that the ads are being represented. Some of these ads have the FDA logo emblazoned up front so that it shows to you that maybe this is a public health alert from a government entity. And so there is a deceptive nature to this, but there's also the public health aspect. We are working with the Federal Trade Commission. We plan on approaching the Food and Drug Administration about taking a closer look at these ads because they are not regulated. The only regulatory source for these ads are the state bar associations. Drug manufacturers, where you see these nice fluffy flowery ads, direct-to-consumer types of advertising that you see on TV, have to get approved by the FDA, whether you're Pfizer, GSK. Those ads are approved, it goes through a regulatory process. Well, that's not the case for these lawyer ads, and they're making representations about the impact of some of these medications that are being prescribed by doctors. My mom, she needs blood thinners, and she's seen some of these ads. She called me, should I take these? I said, yeah, you should. You should talk to your doctor. So it kind of hits home for me, but it's something that we are seeing as a much more of a public health issue. Members of Congress are getting a lot more in tune with what's going on, so we expect some activity on this front. That these ads should get closer scrutiny from the regulators at the federal as well as at the state level. And to the extent that you have these types of regulatory efforts or these safeguards, it could have an impact in terms of driving up the volume of these claims, because the whole game here is to find as many people as possible. These firms aren't even law firms, they're what we call lead generator firms. They give you a number, you call them, and they basically take your intake, take your name, they get your story, and they basically take your file and sell it to a plaintiff firm or a trial firm, and they do it under a fee-sharing arrangement. But it's about generating volume to overwhelm defendants with the number of claimants regardless of what the underlying claims might be. If you have 50,000 claimants in an MDL suit and you're on the receiving end of that as a defendant, you're going to want to settle that pretty quickly. Emerging litigation driver number 3, American Law Institute, or the ALI. How many folks in here are aware of the restatement of laws? Okay, so we all, when you went to law school, you'd have pieces of it that would restate the law. It's kind of in the title itself. What is the majority law? And for hundreds of years, this has been a very good, solid secondary source of law that judges have relied on in order to get a better appreciation of where the majority rules are developing in our common law system. It's an esteemed organization. I actually just joined it last year. You have judges, you have academics, you have practitioners, and they all contribute with input points on what the law is. But unfortunately, over the past few years, the ALI has practically been hijacked by academics who are these reporters who create these massive, massive restatements. And it's much more aspirational in nature. It's not restating the law, it's actually stating what the law should be. So there's a policy component to this. And imagine if you are a defendant and you've got opposing counsel, the plaintiff lawyer, looking at this restatement of law, this authoritative piece of guidance to press their case that maybe we shouldn't rely on things like causation, or what is the duty to warn. And this has been a real problem in a number of the projects that we have seen. We've fought back on this significantly to try and encourage more of a straight-laced viewpoint on the law. But if you get the funding, if you get the people to sue, and if you have elastic laws that judges in certain counties and states can rely on to expand liability, then you have a recipe for disaster. And that, to us, are the 3 unholy elements that can drive a very bad litigation system nationally. Now, does that scare you? Okay, turning to some good news. Let's talk about Montana. Once upon a time, Montana in 2004 was ranked 43rd in the country. The president of the U.S. Chamber of Commerce, Tom Donahue, who is still the president of the U.S. Chamber of Commerce, said very specifically that Montana is one of the most abusive and egregious jurisdictions in the country. He was very vocal about it at that time. And there were a lot of elements as to what contributed to this ranking. And let's talk about this ranking. This ranking is based on a perception poll of in-house corporate counsel with companies that generate revenues of over $100 million or more. It's a diverse group of corporate counsel from the manufacturing sector, financial services, healthcare, tech, and they all are asked questions about various elements of the state lawsuit climate. How are your judges? How are your juries? How are the laws on the books when it comes to summary judgment, dismissals, expert evidence standards, damages? And each category is given a grade from the respondents in this survey and calculated as part of a raw score. So back in 2004, the state of Montana was pretty bad across the board on all of those elements. Treatment of contract and tort law was pretty much at the top of the list as one of the more critical aspects, or critical in terms of bad, in terms of that particular ranking. There were also very negative views about your bench, about your judges, the quality of appellate review. And so I think that this was an important proof point that helped many of the people in this room do what you did over the last decade to bring this state to where it is now at 27. One of the biggest drivers as we look at the raw data for this particular ranking is how venue is treated. And venue is a term that's used in the poll that includes issues like personal jurisdiction and general jurisdiction and due process. I know we're going to talk about the BNSF Terrell case a little later on, but when this poll was out in the field, the Supreme Court delivered that nearly unanimous opinion, save for Sonia Sotomayor, about the principles of general jurisdiction and the Daimler case, where a corporation like BNSF that is not headquartered here should not be hailed into court here, where the alleged injuries happened outside of the state for general jurisdiction purposes. So this is a particularly important point because the Supreme Court has basically locked down on what I would describe as judicially sanctioned kidnapping. And this is, others would describe it as forum shopping. But it's been pretty bad in places like California as well. The Supreme Court also, in the specific jurisdiction context, slapped down the California Supreme Court that tried to authorize out-of-state claimants to bring mass tort cases against Bristol Myers Squibb. So the Supreme Court has been very strong on these particular issues, and it had an impact on this ranking because if you look at one of the factors compared to years past when it comes to venue, Montana was usually in the 40s. Last year, they were number 10, just on the venue point. So that's a huge 30-point swing, and our best calculated, educated guess is because of the BNSF decision, and something that we think warrants a lot of attention and scrutiny. The other thing I would mention about these jurisdictional issues and the impact of these Supreme Court cases is that it's going to really matter for purposes of companies wanting to come here and create jobs. 85%, as you'll, let me jump here. Oop. That 85% number from our poll is the percentage of people who were surveyed who basically said that a state's legal climate matters for purposes of creating jobs, making relocation decisions. And so when you take that sentiment from the corporate community and you ally that with the new Supreme Court jurisprudence on where you can sue a company, if I'm a company and I'm looking in this region, because if you look at South Dakota, they're number 1, and the other states are in the top 10, but I look at Montana at 27, I'm going to think twice. Because if I have a headquarter here, if I have a significant presence here, if I have somebody who can receive service of process, I can be sued here in this state. And so that's going to have an impact in terms, even more so, on business decisions moving forward, and something that I really want to underscore with folks here as you're looking to improve the climate moving forward. But this just gives you a regional viewpoint in terms of the other states who are excelling with their legal climates. Let me wrap up with the 40th President of the United States and paraphrase him a couple of times just to underscore some important points. Ronald Reagan once said that freedom is never more than one generation away from extinction, that you've got to fight for it constantly. It's never just handed down easily to your children. It's got to be protected. I think these same principles hold true for legal reform. That legal reform is less than a generation away from extinction. In other words, the important gains that have been made in this state, your judgment interest rates going from 10 to 3%, some of the better decisions coming out of the Supreme Court, are all things that deserve celebration, but you can't turn your back on it. Because the minute you do, you're going to be back to the 40s. This is what we've seen in Texas during the 90s and 2000s when my former boss, George Bush, was the governor. They did tons of tort reform. But the plaintiff lawyers are still doing a lot of business in Texas, and they're finding ways to get around those laws. They're finding ways of getting active more politically in primaries with the election of state court judges. So my message to you is celebrate number 27, but don't turn your back on it. Work with the legislators to keep pressing this important point. Because without that, the trial lawyers are just going to be at the doorsteps again, pushing the envelope on liability and making the state of Montana an unfavorable place for national companies to invest, create jobs, and establish a presence in. And then one final, since we have Ronald Reagan up here, one final point that I would paraphrase in terms of what he said in the past is that I am from Washington, D.C., but I'm here to help. So thank you very much. Enjoy the rest of the conference. I'm happy to answer any questions. Yes, sir.
On your previous slide.
Hold on, I'll give you a mic, sir.
Sorry. On the previous slide, you had South Dakota as 1 and Idaho as 3.
Right.
What constitutes those ratings?
Well, so when you look at South Dakota, if I recall correctly, they were number 1 across the board in terms of their quality of appellate review. Their Supreme Court is considered very good. And it's just not a state that has a significant amount of active frivolous litigation. Treatment of contract and tort litigation Venue is also strictly enforced. So it's one of those states where, at least from the corporate community's perspective, if you're sued in the state, you have a good idea or some certainty in terms of how that lawsuit's going to be resolved, as opposed to uncertainty and the massive amount of litigation risk that you face in a place like California or Florida. These are the worst jurisdictions in the country. Number 50, by the way, was Louisiana. So if you're ever down there for Mardi Gras or for Jazz Fest, which is, I would recommend, it's a great event. You don't want to be a defendant, though, or on a receiving end of a complaint in New Orleans or in Baton Rouge. So those are some of the factors.
Other questions? Richard.
Thank you, Mr. Kim. I'm deeply alarmed by this third-party hedge fund investment in the lawsuit process, and not to be cynical, but what stockbroker is investing for those funds? I'm just curious for my own IRA. I'm teasing. I'm teasing. No, I just no. My question is a serious one. Has that been opined upon by any high-level court in the country?
Opined upon in terms of its legitimacy?
Yes. Yeah, it just seems crazy. I'm not an attorney. It just seems like that
well,
would
certainly
be
not
allowed.
the Supreme Court of the United States. Although early on, as we saw this stuff emerging, there were some issues about whether it violates these ancient laws on champerty that have been developed, for hundreds of years in terms of the attorney-client relationship. But it really hasn't developed beyond that, and I think that the best way to describe this is that there is an understanding throughout the court system that this is out there, and that there is a tacit approval of it, because there have been some courts that have shielded disclosure of these types of arrangements. And so, but it's a very nascent area, and we do think that Congress, as well as the federal judiciary, they have a role to play here. Yes, sir.
How about the rules of professional responsibility? It seems to me like there's an ethical consideration when you're talking about third-party funding.
Absolutely.
And the rules of professional responsibility are guided by the American Bar Association,
Yep.
and among others. What efforts are being made to have rules of professional responsibility address that third-party funding?
So we did engage early on with the ABA, but as all things with the ABA, they didn't really take a principled position in our view. They paid some lip service. They had a couple of task force meetings to look at this issue, but they weren't going to touch the model rules of professional responsibility and conduct on this. We've tried to go to state bars as well, and what we have discovered is that a lot of these state bars are infiltrated by plaintiff lawyers. And so that appetite to try and pull back from this source of funding, I think, is just going to get a lot of resistance throughout the bars. That's why we got to go to the judges.
We got time for a few more questions. Amy.
Thank you for coming. It's always great to hear from you. I have a question as it relates to some of your examples that you gave us on the judgment interest rate going from 10 to 3%, and that helped in Montana. And then, of course, we talked a little bit about the BNSF case. Do you have some other ideas for us here in Montana that,
Sure.
as you said, kind of keep going forward? I think it's good for everybody in the room to maybe hear. I know you've probably shared them with Webb and Bridger,
Right.
and maybe David.
Well, I know Lauren is going to address this later on today, but there are a few areas where I do think there could be some improvements. One, I understand that phantom damages is a problem here, where it comes to paid versus billed amounts and what the juries can hear in terms of gathering evidence on that. And so that is a reform that has been pursued in other states where you get these inflated damages because the actual paid amount is going to be much less than what the billed amount is. And so because of that inflationary effect, it tends to give inaccurate calculation on damages moving forward. I think you'll hear seatbelt admissibility as another issue. Look, if you're wearing your seatbelt and you get into an accident and you're protected by it, that's obviously an issue in terms of the level of how your injuries are assessed. But if you're not wearing your seatbelt when you're supposed to, and you get injured, it's kind of your fault. And juries ought to be able to hear that. So Lee will speak more to that issue. And then the other point is, I think what the Montana Chamber and the Coalition does on the judicial review document is really important. because I think judges need to know that they are going to be held accountable for bad decisions. And so having good judges, having judges who actually believe in the rule of law and are calling balls, balls, and strikes, strikes, I think is a very important component to it, because you can have the greatest laws on the books, but if the judges aren't going to apply it, then you're back at square one. Okay.
Other
going once,
questions? No?
Going twice. Going home.
I've got actually one real quick. Sorry, Harold, because I do want to make it a bit of a plug too. And one of the great documents that you guys put out on a regular basis is it's pretty much a toolkit guide, 101 ways to improve your legal climate, and it's a great read through, and it's both for the attorney and the layman on these issues. And one of the things I was reading on recently was about the frivolous lawsuit abuse and what state legislatures can do about it, and otherwise. And the issue of loser pays comes up quite a bit. I don't know if you touched on this. I was kind of in and out of the room, but could you touch on the U.S. Chamber ILR's position on loser pays winning attorney fees?
Look, I think in concept, loser pays works, but in reality, it's one way, meaning it doesn't go both ways, meaning that normally a plaintiff, him or herself, is judgment proof. They're not going to be able to pay whatever the fees and costs are associated with that. And what we've seen in America, we've seen it in Texas, for example, they had loser pays. Rick Perry was, singing its accolades, but it's one way. And so it's bad for defendants. If they want to move to dismiss a case, that loser pay provision could affect them, and their calculus is, well, we can get smacked with this, and there's no way that this judge is going to turn the tables on the plaintiff. So I think that is the critical element that ought to be addressed. Thank you. All right, have a great day.